We're indebted to the court, Chief Justice.
Thank you.
Chief Justice, this is a very important matter for our democracy. It's an important matter for all our citizens who are represented by members of parliament, whether those citizens are members of political parties, whether they voted or did not vote, whether they are even not of voting age. But thankfully, important as it is, this is a matter in which the issues are narrow and crisp, in my respectful submission. The only question which arises, and I was using this example when I was talking to the members of my team, to say, let's look at this as a multiple choice examination question. And the question then, bearing in mind that this is a matter that implicates the interpretation of primarily section 102.2 of the Constitution, as well as, to some extent, section 104, or rather Rule 104 of the Rules of the National Assembly. The multiple choice question, I pose it as follows. In respect of the secret ballot as a method of voting, the meaning of the expression, a vote, just those 5 letters, a vote, in section 102, is that a secret ballot is impliedly A, required, B, permitted, or C, prohibited. That is all that this matter is about. The parties will be seeking to various extents to convince you that the answer is A or it's B, as the applicants will do, or that it is C, as the respondents will do. The stances of the parties in general is that 5 of the parties, the political parties and CASAC, say it is A or B. In other words, it is either required or permitted. 2 of the amici, Shosholoza and ISS, say that it is B, but they are neutral as to whether it is also A. And 1, the UPM, says it is B, but not A. In other words, it's permitted, but it's not required. And of course, the respondents will seek to convince the court that it is excluded, prohibited, outlawed, whatever other synonym one can find. Now, the only problem we have is that it is not very clear, and I'm saying this with an eye to inviting my learned colleagues for the respondents. The ambit and scope of the defense or opposition is very difficult to work out. We tried to do an exercise on our side to work out who is opposing what. And it was quite a difficult exercise indeed. For example, the president says that he only opposes prayers 3 and 4. But at certain parts of the affidavit and the heads, and in fact at the end of the affidavit, it is said that the whole application should be dismissed. Similarly, the speaker says that she has no problem with the secret ballot. And her only trouble is that she thinks that she does not have a discretion to order one. And so presumably once that problem is resolved, there would be no problem. But again, at various parts of the pleadings or the heads, it's widened to the extent that she says the entire application should be dismissed. And yet, there is a press statement which is in the papers that she issued and went so far as to say she doesn't know where this notion comes from that she's opposing this application, because she just wants clarity on this and the other. And I'll make a reference to that at a later stage. But be that as it may, we work on the basis that the matter is opposed in different parts by somebody in the respondent camp. What is very clear is that both respondents raise what I call the preliminary matters, which is exclusive jurisdiction or direct access. Or I forgot to mention, Chief Justice and Justices, that the issue of agency is no longer going to be raised. I have cleared that with my learned colleague, Mr. Semenya. So the preliminary issues would be jurisdiction and direct access. When it comes to remedy, it would seem, and of course our learned colleagues will enlighten us when they get their opportunity, it would seem that the President's position is that it would be inappropriate for him to enter the terrain of the Speaker, and therefore he does not express himself on the question of substitution or the review application. But when it comes to remedy, both parties raise the related question of separation of powers. That's the best we could do to work out who is opposing what, which relief. We are going to go mainly on what we call the primary argument, which is that the secret ballot is required or mandatory or compulsory, and we'll be using those synonyms interchangeably. And only in the alternative are we going to talk about whether it is permitted or allowed or discretionary or optional and so on. Now, in doing so, one of the approaches we're going to take is firstly to demonstrate that it cannot conceivably be prohibited. In other words, the only obstacle that the respondents can bring for our case to succeed would be to demonstrate that it is prohibited, and we will show that that is out of the question. Then the only question should be whether is it required or is it permitted. There will be an overlap in my argument, Chief Justice and Justices. When I deal with what I call the primary relief, I will concentrate on Section 102 itself, the interpretation, the preferred interpretation of Section 102 to support that argument. But those arguments will be of equal applicability to the alternative. So I will not repeat them when I deal with the alternative. And what I will then do, with the leave of the court, is when I do the alternative submission, then the main thrust will be the interpretation of Rule 104, bearing in mind that the constitutional submissions will be subsumed therein. But while I still have uninterrupted time, I want to say this. Contrary to all the commentators out there about what this matter is about, this matter is only about one thing and one thing only: the interpretation, what interpretation is to be given to the legal instruments in question. In other words, the Section 102 and the rule. And that is the most mundane and boring and everyday function of the court. When the parties have a dispute, whether it's about a section, whether it's about a contract, whether it's about property, that dispute gets brought to a court because that is the only place where such a dispute can be finally resolved. And so I'm making this point for this reason. This case is not about the separation of powers, nor is it about the so-called encroachment of the court into anything, nor is it about the court likely to introduce anything. If our interpretation of Section 102 is correct, then that interpretation was always like that since 1996 when the Constitution came into being. Nobody's introducing. The court will simply be interpreting what is. And if we succeed on the basis that the secret ballot is required, compulsory, mandatory, and so on, then with the greatest respect, the issue of separation of powers does not come into it whatsoever. Because there the court will simply be saying, yes, Section 102 should be interpreted to say that it is compulsory. End of the story. If it is compulsory, then it's compulsory tomorrow, next week, next year, in 20 years' time, and so on. And that's the end of it. Only if the court, on the other hand, finds in our favor in respect of the second leg, in other words, that it is discretionary. And even then, when it comes to the question of remedy and the question of substitution in particular, clearly then issues of separation of powers become relevant in that narrow sense, because by definition, substitution means basically making the decision, for the court making the decision.
The 10 minutes is up.
Oh, well, Chief Justice, if you can permit me then to make the final point, which is this, that we will, in a nutshell, we will also ask for a special order against the president to pay costs personally and from his own pocket. And that I will address later. But in a nutshell, it is the complaint we raise is that the president was cited as a president of the country, and the ANC was cited as a party. The ANC chose not to get involved in this matter. But the president, using the state attorney or taxpayers' money, has sought to make submissions on behalf of the ANC, which is his private life or interest, so to speak. But we'll deal with that later. But finally, by way of introduction, I want to deal with what I'll call the atmospheric issues.
Are you still pleading for protection there, or may we?
Half a minute. You
see, I offered you people 15 minutes. You said 10 minutes is enough.
Half a minute, Chief Justice. And it is simply to say this. If the Speaker is to be believed that she has no problem with the secret ballot for a minute, and that she seeks, and one has sympathy with that argument, because insofar as she says, look, there's a Kawama judgment, and maybe I think I'm constrained by it, rightly or wrongly, then one can understand that. She needs clarification. If that is so, then really what do we have here? We have the following situation. The only person in this country who is opposing the application that the motion of no confidence in the president of the country should be conducted by secret ballot is the president of the country. I will say something more about that later.
Mr. Mpofu, I'm sorry. Shouldn't you start with what you described as preliminary issues? Why should we entertain this matter? What is the basis for us to hear it?
Yes. Thank you, Justice Chapter. We should. Well, the main thrust of these preliminary issues is the question of exclusive jurisdiction. Our submission is simply this. The entire source of I'm going to say that there are what I call sub-obligations and powers and so on. But the source of all this is the obligation on Parliament to hold the executive accountable. That obligation is by definition exclusive to Parliament, to state the obvious. But to travel from that obligation to the obligations that are pleaded here, we then say the following. In the discharge of that obligation, broadly speaking, in fact, let me put it like this. That obligation starts the minute that members of Parliament are sworn in. That obligation arises until the next election. And in the continuum of that obligation is the question of the motion of no confidence. It can manifest itself in various other ways, which I don't need to go into now. And the motion of no confidence itself is, if you like, with respect, can be viewed as an obligation, except that it's now almost an obligation on the president. The section says, to paraphrase, if a motion is passed, the president must resign. It could also have been worded the other way. The president must resign when a motion is passed. So it's an obligation on his part to do something.
Mr. Mpofu, I'm sorry, and it may well be that my brother still wants to put further questions to you. Just locate the obligation for us. In the clearest of terms, what is the obligation that rests on Parliament on which reliance is placed for this application? Just locate it for us.
Well, that obligation is to vote in a motion of no confidence. In other words, once a motion of no confidence has been placed, there are three obligations that arise. One is on the Speaker to schedule such a motion, and then the obligation on the members, Parliament, broadly speaking, the National Assembly, let's put it that way, to vote. And also an obligation on the National Assembly to debate the motion. Those are the threefold obligations. But narrowly...
No, you were going there. I just wanted a section and a subsection so that we know whatever argument flows from here hinges on this section of the Constitution.
Those obligations, Chief Justice, correct, arise from 102.2 itself, and also the ancillary obligations on the Speaker, which is really why we're here, arise also from the rules. So in other words, the Speaker has a duty, at the very least, to schedule, to allow for the debate or arrange for the debate, and also to arrange for the vote. And we locate the obligation here that in her obligation to arrange for the vote, she has also an obligation to, when asked, as she is asked now, to choose the method of voting to do so. She has abdicated, to put it bluntly, that the discharge of that obligation, and that is why we're here.
But the Speaker is not Parliament, is she?
Well, she is and she isn't. She as she has accepted that she has been cited as the representative of Parliament. So she's the embodiment of Parliament. When somebody is litigating against Parliament, we cite the Speaker in that fashion.
Doesn't the Constitution define what Parliament is, Mr. Mpofu?
Yeah, no, of course, the Constitution does, but what I'm saying, Justice Chapter, is that the Speaker must be seen in her multiple roles. She says herself in her answering affidavit, I'm cited here as the Speaker, I'm also cited as a representative of the National Assembly per se.
But should we go by that? Shouldn't we go by what the Constitution says, tells us what Parliament is, when we are searching for determining whether Parliament has failed to fulfill one of its obligations?
Yeah, yes, of course, it is like that, Justice Shafter, but just as when we say the Department of Home Affairs has failed to do something, that Department of Home Affairs is just an inanimate thing. That the person who has really failed is either the DG or the minister, depending on the matter. But you can't say the Department of Home Affairs. There's no such thing as the Department of Home Affairs. It's just a fiction. So the real department is represented by an official who is designated constitutionally to represent that institution. And that's all we're saying. We're saying the Speaker then comes in two guises, as the Speaker, but also as the representative, the constitutional representative of Parliament.
But Section 167, which carves out the exclusive jurisdiction of this court, make reference to Parliament.
Yeah.
And the Constitution tells us what Parliament is. Why should we include the Speaker in the description of Parliament?
Yes. Well, Justice Shafter, I can't take it further than to say, yes, the Constitution says Parliament, but Parliament is not a person. That section 167 also says the President. There it's easy. We know the President is a person. But when that same section, 167(4)(e), says Parliament, it obviously is not referring to a human being. It's referring to an institution. And that institution, constitutionally speaking, is embodied, represented by the Speaker. So otherwise, Parliament could never do anything. If you are never going to be able to pinpoint that it was either the Secretary of Parliament or this one or that one who did whatever they had to do, then you will never be able to come to this court on the basis that Parliament has done anything, because Parliament is just a fiction of law. So
let me just make sure I understand you.
Yeah.
And let me know if what I put to you is not what you're saying. Am I to understand you to be saying that the point that demonstrates the obligation that, according to you, rests on the Speaker and by extension Parliament, that has not been, that she has failed to fulfill is the following. Section 167(4)(e) reads, only the Constitutional Court may decide that Parliament or the President has failed to fulfill a constitutional obligation. And as I understand you, and that's why I want help from you,
Yes.
You seem to be saying the obligation that rests on the Speaker is to ensure, as identified by the National Assembly, to ensure that when a request for a motion of no confidence is asked for, that happens the way it is required by the Constitution to happen.
Yeah.
And according to your submission, the way the Constitution requires that a motion of no confidence in the President be handled is by secret ballot.
That's correct.
So if the Speaker is asked to have a motion of no confidence scheduled in a way that will allow members of the National Assembly to vote by secret ballot, if she does not do that, according to your submission, she has failed to fulfill the obligation to have the motion of no confidence
That's
conducted. Is that what you are saying?
That is my submission, Chief Justice. And that submission rests solely on the fact that Section 102 says the National Assembly must do these things, must vote, must do this, but the rules are very clear who should organize, so to speak, all that. And our case is very simple, that the Speaker, on the primary relief, the Speaker has an obligation to arrange for a secret ballot. That's our primary relief. Whether we're right or wrong for the purposes of jurisdiction is another matter. For the purposes of jurisdiction, it is about what are we pleading. We are pleading that the Speaker has such an obligation to arrange the secret ballot. And she has failed to discharge it. That is all. We might be found when we get to the merits to be wrong on that, but for the purposes of jurisdiction, we must be judged by what it is that we've brought to this court, which is simply that she has failed to discharge that obligation. That obligation arises, yes, it is ancillary, that I concede, but it arises from the obligations that spring out of Section 102.
I'm sorry, Mr. Mpofu.
Sorry.
Just for clarification, going back to the question that was asked by my brother, Justice Chapter, just now,
Yeah.
with regard to Parliament. Now, as I understand the Constitution, Parliament consists of the National Assembly and the National Council of Provinces. Now, does the Constitution or the law permit the Speaker of the National Assembly alone to represent the entire Parliament, or you would have had to cite the chairperson of the National Council of Provinces as well?
Well, two answers, Justice Sondo. One is that, once again, if the business about which we are here, let's say Parliament had 3 or 4 chambers, but if the business about which we are concerns one of the chambers, which is represented constitutionally, as I've explained, by a specific person, then that person, with respect, would be sufficient to cite to represent the institution, number one. Number two, that point, well, is not a point that has been raised, and for good reason. Because in all this litigation, whether it's Tlowama and all the other cases that have come before this court, the person who gets traditionally cited is the Speaker, on the understanding that I've just articulated, whether it was the EFF Nkandla case, whether it is this one, and all the cases where Parliament is implicated. And the reason for that is also to be found in Section 23(2)A of the Powers and Privileges Act. which simply says, 23(2)(a), for the purposes of subsection 1, where appropriate, that's a reference to the State Liability Act and so on, of a minister, department must, where the proceedings are against where the proceedings are against Parliament or a House, coming to what you raised, Justice Chapter, be construed as a reference to the Speaker or the Chairperson, or both the Speaker and the Chairperson, as the case may be. In other words, a litigant, there would have been nothing wrong if we had followed the route that Justice Zondo suggests. We could have cited both, could have cited the one, or we could have cited the other. And we have cited the other.
Well, I'm sorry, you might have to repeat the provision you have just read.
Yes, it's section 23(2)(a).
Okay. I got the impression from what you read that what is meant is that if you seek to cite somebody in respect of the National Assembly, then you would cite the Speaker.
Correct.
If you seek to cite somebody in respect of the National Council of Provinces, then you would cite the Chairperson of the National Council of Provinces. If you seek to cite somebody for Parliament, I don't know if it goes that far, I'm just thinking now, maybe you might need to cite both. Maybe you might just read it again.
Yes, no, with respect, it says Parliament or a House shall be construed as a reference to the Speaker or the Chairperson, or to both the Speaker and the Chairperson, as the case may be. But in any case, section 42(3), when I started, I said all these obligations can be traced back to section 42, or rather to the 42(3), yes. 42(3) that we're about here says the following: the National Assembly is elected to represent the people and to ensure government by the people under the Constitution. It does this by choosing the president and so on and so on. So really the obligations that we're about here today lie on the National Assembly. Hence, if you read that section of the Constitution together with 23(2)(a), then the person to be cited would clearly be the Speaker.
I'm not too sure I understand your answer, Mr. Mpofu. I thought your, at least in my own mind and clarified, it seems to be different from your own understanding. I thought, to the extent that section 167(4)(e) refers to Parliament, and section 102 refers to the National Assembly, and the National Assembly is not Parliament, it's a segment of Parliament, one of the two houses of Parliament. Your reliance on the Speaker would stem from the same basis as in the EFF case that we decided, namely, requiring of the National Assembly to hold the President accountable in terms of Section 55 of the Constitution. Let me put it differently, I'm sorry. 167(4)(e) refers to Parliament, but 55 refers to the National Assembly. And yet, for the purpose of determining whether this court had an exclusive jurisdiction, knowing that section 167(4)(e) refers to Parliament and not the National Assembly, whereas 55 confines itself to the National Assembly, we were still able to decide that a reference to Parliament in 167(4)(e) should be understood to permit of a situation where the National Assembly is singled out to do something, as in Section 55 of the Constitution. I don't know if I'm making sense.
That's exactly,
to you. So a reference in 102 to the National Assembly is the same as a reference to the National Assembly in 55.
That is correct.
You can't use, is it State Liability Act? You can't use that to interpret the Constitution. You've got to use the Constitution and existing jurisprudence to interpret the Constitution.
Of course, Chief Justice, that is not what I was doing. What I was saying is, let's say, for example, there was a rule of court that says you will only cite the Speaker. I would cite that rule, but I wouldn't be using that rule to interpret the Constitution. And what the Chief Justice has articulated is exactly what I'm saying. The 102 is our starting point, and the obligation, power, whatever you call it in 102, is on the National Assembly per se. And everything else then flows from that. Section 55, as the CJ correctly points out, and also Section 42, which I've just read out, all refer to the obligations of the National Assembly. And on the same basis in the EFF case and in all the other cases. So
I was only saying there is a case that says, effectively, in circumstances where the National Assembly is said to have failed to fulfill its constitutional obligations, we already have authority that says, if you want to check whether Section 165(4)(e kicks in, and it's only the National Assembly that is referred to in that section, then there is authority.
That's correct.
Yes.
Mr. Mpofu, I'm sorry. I think my inquiry was a different one. I started by bringing your attention to the provision of the Constitution that defines Parliament. And that provision is actually Section 42. And it tells us that Parliament consists of the National Assembly and the House of National Provinces. Now, the issue is whether, in the context of Section 167, for purposes of exclusive jurisdiction of this court, whether we should read National Assembly as meaning the Speaker. I thought the Speaker is one of the members of the National Assembly. So if we can read National Assembly to mean the Speaker, if at some point she takes a decision, that decision should be attributed to the whole National Assembly, then I would understand the argument.
Yes, well, it is the argument, Justice Chapter. When Mr. Ngamayo Mzinkwankwa wrote on behalf of the UDM to the Speaker asking for a motion of no confidence, he was not writing to Ms. Baleka Mbete. He was writing to the National Assembly, which is tasked in terms of Section 102 to do something. But he couldn't just write a letter and address it to the National Assembly. He had to address that letter to the person who, in terms of the section, the State Liability Act, the Powers and Privileges Act, is by law the embodiment of that institution and is the person to be cited when that institution is being taken to task. We are saying, I agree exactly with that formulation. So it's the Speaker, both in the failure to carry out the obligation and in her being cited here, is the embodiment of the National Assembly. As court pleases.
Mr. Mpofu, as you know, it's either exclusive jurisdiction or direct access. If you could also address us on that point.
Yes. And
in particular, the allegation that the applicant should have exhausted internal remedies, and how you say, I can't pronounce it, is distinguishable, because there's also the allegation that applicant should have appealed that judgment, yes, and he did not do so.
Well, very briefly, Justice Mhlanhla, what we're saying there is that, and again, I won't repeat the test, in the broad context of the interest of justice, we are saying, and given the fact that this is a matter that is inherently urgent, we're saying, assuming then that we had taken the matter against the Speaker, then we would have had to go to the Western Cape High Court. And one of the issues that relate to Tlawama, which we would like the court to consider in the broad consideration of the interest of justice, is this. Putting aside the fact that we are saying Tlawama is distinguishable, because remember, we're saying Tlawama is distinguishable, but we're also saying it was wrongly decided. So we're saying two things about Tlawama. But if we had gone on an urgent basis to the Western Cape High Court, bearing in mind that Tlawama was a full bench decision, then that court would have been bound by Tlawama. So that's the one thing we say about Tlawama to be considered. And therefore, it might have been a futile exercise to do that. But secondly, what we say is that Tlawama also, maybe fortuitously, resolves another impediment which is always on the way towards direct access, namely that this court is reluctant to be the court of first instance on an issue. Tlawama, therefore, then provides a situation where the question was decided wrongly, in brackets, but nevertheless was considered and decided in a lower court. So Tlawama serves those two purposes. One, the futility approach that I've spoken about, and secondly, it fortuitously takes away the impediment of this court in reality being the court of first instance.
Please go back to my sister's question in case you haven't completed your answer. But could the Speaker do anything when Tlawama is there?
Well,
without disregarding a court decision?
Yes, she could. That is why in my 10 minutes, I specifically said, we have great sympathy with the position of the Speaker. Because the Speaker is not a lawyer. She's not going to pick up the judgment and say it's distinguishable and all those things that we say as lawyers. So we understand. But remember, for example, when we deal with the rationality of her decision, the test is objective. So it doesn't matter if subjectively she thought Tlawama binds her. It doesn't matter. If Tlawama, in actual fact, is wrongly decided or distinguishable, as we say, particularly if it's distinguishable, the IFP, I'm sure, will raise that point. The IFP raises the point that Tlawama actually is distinguishable on the grounds that it was a case decided on another set of rules, not these rules. That is a criticism that we have. But we say, assume that was not there, it is also wrongly decided. So whether it is because...
I'm sorry to interrupt. You know we interrupt, Mr. Mpofu.
No, of course.
No, I'm not even there. I'm saying, here is the Speaker told that, this section 102, subsection 2, demands of you, requires of you, to arrange that voting on a motion of no confidence against the President be by secret ballot. And she's confronted by Tlawama judgment, which says, but there is no way in which this motion can be conducted by a secret ballot. How does she disregard a court judgment like that? Even if she thought it was wrong, it's there.
Well, Chief Justice, with the greatest respect, then we must go back to where this matter comes from. This matter comes from the letter of demand that was written on behalf of the UDM.
Mr. Mpofu. Sorry, Mr. Mpofu. Mr. Mpofu.
I'm listening. Yes,
yes.
Just.
The question by the Chief Justice assists you. Mr. Mpofu, I'm trying to point out that what the Chief Justice is pointing out is that the Speaker could not have taken any other decision in view of Tloama.
Yeah.
And therefore, it supports your submission that you are entitled to come here and ask for direct access.
Absolutely.
Thank you.
No, but that's a... why else am I saying this? The only reason I'm saying this, Justice Chapter, is exactly to agree with the Chief Justice. I am saying this is why I said it in my introduction. We have sympathy with the Speaker, but that sympathy ends at the point at which she was bound in her mind by Tloama. The only other place we could go to is here. That's all I'm saying. Yeah, probably. Yeah. Well, thank you. So that's the end of the preliminary issues. Now, oh yes.
You are left with 15 minutes.
Thank you, Chief Justice. Yeah.
Mr. Mpofu,
yes,
perhaps you should just go straight and tell us why you say the vote is required or permitted to be by secret ballot.
Thank you. Well, we say this based. Firstly, we say that the vote is prescribed to be by secret ballot because it is common cause that a secret ballot is what we call a constitutionally permissible method of voting. And I'm saying that as a precursor to something else. Why do we say it's constitutionally permissible? When we invoke Section 86 and the procedure in Schedule 3, we invoke it for two reasons. The first reason is to make this point that this is a constitutionally permissible method. And it immediately does away with one of the defenses that are raised, namely that we want to introduce some secret society, or that the values of openness and transparency and so on will be undermined. We say that that cannot be so. If that was so, if a secret ballot was such an animal, then the Constitution would not prescribe it under any circumstances. In other words, the value judgment, the hierarchy of values, so to speak, if you take it to Section 1D, which talks about all these things. It talks about accountability, it talks about democracy, it talks about transparency, it talks about openness. We say in this context, the hierarchy of those values is already determined by the Constitution. Because the Constitution has said, yes, there will be so-called encroachment into openness. But because of the bigger values of protecting the voter, then we will allow a secret ballot. It's the same in Section 19. Section 19, of course, it would be nice if all the citizens would vote in the open and raise their hands. That would be great for openness. But the Constitution, the drafters of the Constitution in their wisdom have made the choice of values to say, no, we know that would be great for openness, but we're going to prescribe that the vote must come by way of a secret ballot. And that argument, it goes right to the international stage. The United Nations Declaration for Human Rights, no less, knowing all the importance of openness, says that the vote internationally must be secured by way of secret ballot. So it is that submission. But the second reason why we invoke Section 86.3, Section 86 together read with Part A, is what we call what I call the Masetla congruence. In other words, we're saying, we use a rhetorical question, maybe is the best way to approach it. Why is it that the Constitution prescribes a secret ballot in Section 86? The answer must be simple. It is to protect the voter. Against what? Against possible intimidation, not necessarily all intimidation, but the risk of intimidation, the risk of any threats, the risk of any adverse consequences. When we say the citizens must vote by secret, we're not saying that in every voting station in this country there's somebody standing there to intimidate somebody. That would be ridiculous. What we're saying is the mere risk or potential or likelihood of such a thing happening constitutionally compels us to prescribe the secret ballot.
Mr. Mpofu, isn't there another reason why the Constitution mandates a secret ballot when more than one nominee is nominated for the office of President? Isn't it because the execution of the office of President is deeply connected to the personal attributes of the person who's up for election? And that therefore at that level it's not simply a nominee from a party, and that MPs are required to vote for the person of that individual who will become president in their individual capacities.
Yes, no, that is definitely so, Justice Cameron. But our short answer to that is that just as those considerations are important when we choose the president, the same considerations must be important when we unchoose the president. In other words,
I'm glad you're better able to discern the questions that are designed to assist you, Mr. Mpofu.
Yes, thank you. As God pleases. And welcome them with both hands, as God pleases. So that then is the ground for 86.3. Or for invoking 86. But there's a more maybe dramatic reason. And it is this. The Speaker, I call it the crime prevention rationale. In its wisdom, the Parliament has declared intimidation of members of Parliament a crime. That is Section 7 and 8 read with Section 27 of the Powers and Privileges Act. So then surely that must put an obligation on the Speaker simply to do what she can do to prevent that crime from being committed. And that cuts both for the primary and the secondary relief. Because in this particular case, it so happens that the crime, quote unquote, has been reported in the letter of demand. But in the notional situation, the crime is a potential that is always with us. Just as fraud, bribery, corruption of voters, and so on, those ever-present risks must be ameliorated. And the shortcut answer is that of the available methods, the only method that can prevent that crime from either being committed in real life, in this particular case, or as a risk that is always there, is the secret ballot.
Which crime has been reported?
The intimidation.
Which one?
Section...
No. I know the section. I thought you said a crime has already been reported.
Yes.
So I was wondering which crime has been reported
yes.
now.
I will assist you, Chief Justice. The letter of demand says, I'll paraphrase. Letter of demand says, Dear Speaker, there's a motion of no confidence. It has come to our attention that there is intimidation that is taking place. In any event, and then it quotes the sections that we have already dealt with. Therefore, please arrange for a secret ballot. So that is bringing to the attention of the Speaker in this balance the crime specifically. But what I'm saying, Chief Justice, is that even if that was not the case, the ever-present danger of intimidation is what propels Section 19.3 to make all of us to vote by secret ballot.
Shouldn't we go there? Because it toxifies the engagement. If we're going to have to, as a court, take into account that some crime has been reported, it raises all sorts of, by who? Is it a crime? Also, shouldn't we just look at the law and interpret it?
Yeah, but
crime or no crime, suspected or real, just look at the law and say, what is the meaning of Section 102.2? Why is Section 86 couched in this manner, read with the schedule? What undergirds the approach in Schedule 3, Part A, Item 6A? Why do we have it like that? Yeah. Why is it necessary when the president is elected to do it by secret ballot?
Yes.
What are the concerns there? Do they or do they not extend to the removal? Which one is potentially more perilous than the other, if there is any peril?
Yes.
Is it when you entertain the hope to be elected, or when you face the risk of being denied of what you already enjoy? Shouldn't we be engaging at that level? Because now if we're going to say, yes, there's an offense, there's some criminal activity, it just makes it all the more difficult for the judges to do justice to the issues.
I think there's a misunderstanding.
Yes.
I was doing exactly what the Chief Justice is saying. It's called the mischief approach. I am saying, why? That's why I said I'm asking the rhetorical question, which is exactly what the Chief Justice, with respect, is saying. What was the mischief that propelled Parliament to, or the Constitution rather, to prescribe in Section 86 the secret ballot? That's exactly what I'm saying. And I'm saying that mischief includes actual or perceived or potential risk of intimidation or fraud. That is all. And that potential, with the greatest respect, I agree with the Chief Justice, that potential risk, whether it happens to be actual or not in this case, I agree should be put aside. But that ever-present potential, in my respectful submission, is present, is more present now. Or let me put it in a different way. Its realization, or even its mere presence, is a threat to the effectiveness of the Section 102, the operation of Section 102. And many adjectives have been used here to say that it would then be illusory, nugatory, warped, is the expression that Justice Madlanga used in the DA case, meaningless, blunt, all sorts of things. But that's the essence. The essence is that that right would be denuded of its essence, of its purpose, coming to the question of purposive interpretation, and might as well not happen. In fact, we might as well not have the Section 102 if it can be so denuded of its character and impact and teeth. Toothless was the other adjective that was used. So it would be rendered all those things. And surely then, if we have all those ailments, and we are saying, here is the antidote. To all those ailments, there is only one antidote. That antidote is the secret ballot. Immediately, the teeth are back, all the strength is back, the Section 102 is given its power back. That is the crux of the.
If I may, just for the benefit of other council that will debate, that will make submissions later. Here are my concerns, and I would be helped speaking for myself if this were to be addressed. One, why does Section 19(2) of the Constitution require a vote by secret ballot? Why does Section 86, read with Schedule 3, Part A, Item 6A, require a secret ballot in relation to the President? What is the logicality of discounting a secret ballot when it comes to a motion of no confidence? And I confine it to a motion of no confidence because that's where we are. Why do we believe that considerations that explain the need for a secret ballot in relation to Section 19(2) and the schedule do not extend to a motion of no confidence? Is it because it's not written? What are we to make of the Botswana judgment that you refer to? What are we to make of the Zimbabwe Supreme Court judgment that you referred to and other of your colleagues also referred to in their heads of argument? Just a simple explanation that everybody can relate to. I think we'll contaminate, for want of a better expression, and I say it with all the respect, nobody should feel offended. We stand the risk of being diverted, our attention being diverted elsewhere. If we bring in, on whom was an assassination attempt, for what reason, and so-and-so says so-and-so was intimidated. I'm not too sure we should even reflect on those things, because the law is there.
Yes.
Regardless of what is said to have happened. How is this law properly interpreted, or this constitutional provision properly interpreted to be applied in a situation like this, regardless of who is the incumbent and whether we like or hate the person? That's irrelevant.
Completely.
So I think, speaking for myself, if I were to be addressed on those issues, I would find a lot of help.
Yes. Chief Justice, that is the point. If I didn't make the point in my 10 minutes, well, I'm making it now. The issues of intimidation, this one phoned, this one, do not enter into our primary...
SMS and all those things.
It doesn't enter into the primary obligation at all. Just as I said, all these other issues about separation of powers and so on, the question is very simple. If we apply a constitutional interpretation of Section 102, a holistic, schematic, systematic interpretation as we are prescribed to do, and this is a challenge I'm putting to my learned colleagues, they must then tell us in that context, what is wrong with the secret ballot? Why must it be excluded? Because their case can only be that it is excluded. Why would it be excluded? We're busy giving you reasons, and many parties will, as to why it must be there. But nobody has told us what is wrong with it. And all the things that have been put up, party discipline and so on, do not answer the question, which is that a method that is constitutionally permissible for all the reasons, whether in Section 19 and all the other sections, Section 111 and so on, is now said to be, because of the vitality and all the things we know from Mazibuko of this particular, and the risk, and I put it no higher than that, the risk of the outcome being contaminated, whether that risk is going to materialize in this or the next or in 100 years' time, it doesn't matter. But the mere risk of the outcome not reflecting the real thing that all the South Africans want to know, Chief Justice, with respect, is very simple. Does the president continue to enjoy the confidence of the majority of the members of parliament. That's all. Now, if he does, well, then he does. But to answer that question, just as we do in the elections, the question is simple. Which political party enjoys the majority support of South Africans? And we bring the secret ballot to make sure that the answer that we get must have integrity. It must be the real answer. It must be untainted by any extraneous factor, whether that factor is fraud or fear or whatever. And that is all. It's a very simple antidote, as I call it, that we are waving respectfully to this court to say, here is the antidote for all these ills, real, potential, whether they've happened or are still going to happen, or whether they're not going to happen right now in this particular. And therefore, that brings
Mr. Mpofu,
Justice Matlanga.
It's quite plain from sections 19 and 102 read with the relevant schedule that the framers of the Constitution were quite alive to the need for a secret ballot. Can't an argument be made then that they must have consciously decided not to prescribe it when it came to a vote of no confidence?
Yes.
Can't it be said that, well aware of the need for it in the instances where it has been specified, that perhaps they chose the openness, transparency, and so on, which in your submissions you did say is also a relevant or may well be a relevant consideration? Can they be said to have made a conscious choice and said, when it comes to a vote of no confidence, we are opting that there be no secret ballot?
Mr. Mpofu, before you respond, may I latch on what my brother has just stated? My own concern is what should we make of the fact that the Constitution in some places expressly requires a vote by secret ballot, as in Section 19 and Section 86, but does not do so in Section 102, subsection 2. It's just to latch on what Justice Matlanga has just put to you.
And please, I'm aware of the authorities that criticize the use of the expressio unius exclusio alterius principle. So I'm not there at all. I'm at an interpretative level.
Yes. Well, unfortunately, Justice Matlanga, it's just the Latin. It's just the Latin. But the sentiment that both Justice Matlanga and Justice Khambembe are expressing is embodied in that maxim, quote unquote. And it makes sense that if in a statute the law says this and this will happen and then doesn't say it in another section, then the presumption would be that it was meant to exclude it. But it has been authoritatively said that that type of reasoning is not appropriate with respect to what the Canadian case called charter interpretation.
May I interrupt you, Mr. Mpofu? What my sister and my brother are saying is this. Could it be that the drafters of the Constitution, mindful of the principle of separation of powers, wanted this arm of the state to bear the responsibility to decide how they would want a motion of no confidence to be conducted?
Yes.
Because they knew they are the ones who included secret ballot elsewhere. Could it be that they left it to the National Assembly? Whenever you people think that it must be by secret ballot, it's up to you. Whenever you think that it should be by open ballot, it's all up to you.
The first answer is it could. I'm going to show why it isn't so. It could. And if it could, if even that formulation, Chief Justice, would be sufficient for us to succeed on the alternative ground. In other words, as the Chief Justice says, the law would then be saying, we are neither prescribing nor prohibiting the secret ballot. But then what are we doing? Then what are we doing is what is in prayer 3.2. We are then saying, it's up to you. If and when you think it should be done, it will be done. But that is a far cry from what is being contended by the respondents, namely that it's excluded. But let me now address the second question, which is why it is not by the use of that, or rather why it is prescribed nevertheless. The reason, with the greatest respect, and that is debated in the Botswana case, in both the lower court and the higher court. The reason the expressio unius kind of reasoning is not prescribed or says ill-suited for constitutional interpretation is exactly because it is best suited for statutory interpretation. Whereas in constitutional interpretation, what we are compelled to do is to look at the scheme of the Constitution. Now, if you're going to look at the scheme of the Constitution, you will never get anywhere by saying, well, if in this particular provision it's not there, therefore it means it is excluded. Because as Mr. Unterhalter will explain later, one has to look at the entire Constitution, including the Bill of Rights. One has to consider that, after all, these members of Parliament are also citizens of South Africa. They have the right, in terms of Section 15 of the Constitution, the right to freedom of conscience. They have the right, in terms of Section 16, to freedom of expression. If you want to go to the intimidation route, well, they have a right to life, they have a right to personal integrity, and so on and so on. So, a schematic, you will never get anywhere by using the expressio logic in interpreting a constitutional provision, because by definition, it is unsuited for that. So we cannot say the drafters. In fact, constitutions, by definition, this thing called a constitution, whether it's a constitution of a country or of a football club, is a framework. It's a framework. It will never foresee all possible situations. Life gets breathed into it by situational happenings.
I'm sorry, Mr. For Mpofu. Motion of no confidence is there.
Yes.
You know it is there. You're prescribing for how to vote a president into office, but you're not telling us how to vote him or her out of office, you see. I'm just making the statement in passing that one is not some development that might arise in the future. It stares you in the face as you craft the Constitution.
Yes, well, that is so, but so does it, all the Masetla logic, so to speak, is exactly based on that. Whenever the instrument being examined, such as was being examined in Masetla, is silent. That instrument was silent on how the DG of intelligence should be fired. And that did not mean that the drafters of that act thought that he should never be fired. It was silent. And therefore, the court then says, okay, well, where does this power, what is the closest other power, the ancillary power? It is the power to hire. And the court then says, well, in that particular case, he who hires, fires. Now we're saying, as the court, please, in that case, it was a he. President Mbeki. Yeah.
Mpofu, just on the point you are dealing with,
yes,
I have reservations whether you are correct to invoke the unius rule of presumption to deal with the question that has been raised, questions that have been raised by my colleagues Justice Chapter and Justice Kampebe, because my understanding is that when one seeks to interpret a constitution, one of the things that you have got to bear in mind is that the drafters of the Constitution may have made certain choices, which, for example, the judiciary must respect for good or bad reasons. To bring about a constitution, a complete constitution, there are certain issues that they had to deal with, and in regard to those issues, there may have been different views from different stakeholders, different political parties, and they make certain choices.
Yes.
And the judiciary should not, if possible, interfere with those choices. Now, as I understand the question that was put to you by my two colleagues, it is that when you look at the Constitution, you see that in certain sections and in respect of certain office bearers or functionaries, the Constitution is clear. It prescribes a secret ballot. It doesn't give a discretion. It prescribes a secret ballot. So that means, that seems to suggest that for those situations, the drafters did not want to leave it to somebody to decide whether this time it should be a secret ballot, this time it should not. And then they say, in a number of sections, then the Constitution doesn't prescribe a secret ballot.
Yes.
Are we therefore not dealing with a situation where the secret ballot is not prescribed? That was not as a result of oversight. That was deliberate. For whatever reasons that we may or may not think about. Yes. And therefore that to a very large extent, we must try and give effect to those choices that have been made.
Yes, I understand the question, Justice Zondo. But my answer is this. Firstly, as I said to the Chief Justice, even if that were so, that would not operate to exclude the secret ballot. So we would still have to succeed on the alternative. But let's put that aside. As far as the primary prayer is concerned, the answer is this. Yes, of course, Justice Zondo, it's possible. Anything is possible. But my job is to convince this court that that choice was not made, that that choice would be illogical in the totality of the circumstances, that that choice might even be oppressive, that that choice might take away the teeth from the intended effect of Section 102. And therefore, and even more, if that choice was going to be situational, and this time it's secret ballot, next time it's open ballot, tomorrow it's by standing up or sitting down, that would create chaos because, as pointed out by one of the amici, then it would mean that every time there's a motion of no confidence, we must come back here. Somebody this time will say, I'm applying that it must be open. In 2 years' time, I'm applying that it must be secret. So that could not have been the intention of the drafters of the Constitution. And that is what I have to do.
But Mr. Mpofu,
am I right?
Mr. Mpofu,
I'm sorry. Am I right to think that in order to uphold your primary contention, this court would have to say there was no choice made, but it was oversight?
Yes, and it would also have to say the following, Justice Zondo. Again,
before you continue, I must just complete.
Yes.
If you say, this court would have to say it's oversight, which we have said we we would need to say, but you want to add. If you say this court would have to say it was oversight that in some cases they didn't say prescribed secret ballot. Part of my difficulty would be, it seems to be quite a number of places. Could one really be able to say in all these other cases it was oversight?
No, absolutely not. One would not be able to say that. But one would be able to say it when the subject matter is so identical, congruent, a mirror image of those situations where it is prescribed, that it would be absurd to say that it is not.
Mr.
In other words,
may I interrupt your answer?
Yes.
Does it help us at all to go back to the death penalty debate? Because there it was an express, we don't have any suggestion from the parties that in the preparatory work, travaux preparatoires, there was any debate about this. There's a silence in the Constitutional Assembly history so far as we've been told by all the parties. But in the death penalty debate, there was a lot of debate, and the parties differed. And they agreed to leave it out of the Constitution, which doesn't mean that the Constitution doesn't have a meaning. So does it help us in any way to determine the meaning of 1022?
Yes, that is correct, Justice Cameron. In other words, really, my broad submission is this: an omission is not an exclusion. Simple. And the second stage to that is that, because that is the mistake that the respondents make, that an omission ipso facto is an exclusion.
I'm sorry to interrupt you.
Sorry.
If the omission is not necessarily an exclusion, and the choice is not clear from the wording of the Constitution, how do we then determine it? Is the real question then not to ask how best is the purpose of National Assembly oversight over the executive served by either a secret ballot or not?
Yes, absolutely, Justice Fromneman. The purposive approach helps us. But with respect, what I'm saying is that it would not also be true to say the choice is not clear, because the drafters of the Constitution, in what I would submit are almost identical situations where the dilemmas are the same, where the vexing questions are the same, the dangers are the same, and so on, has prescribed an antidote. All I'm here saying humbly is that that antidote, which is prescribed for those situations which are similar, identical, I don't know, on the continuum of the mirror image, that antidote must have been, that's my argument can only be, must have been contemplated. If it was not, then it was either an oversight or, as in the death penalty situation, it was a question deliberately left for this court to decide. Because Justice Cameron is right. Nobody in their right mind can think that it didn't occur to the drafters of the Constitution that there's something called the death sentence. But they crafted the Constitution in its totality in such a manner that it would be settled, this court would be settled with that question. And this court rose to the occasion and answered that question. I'm saying it is that species of an omission. It is not an omission which is ipso facto an exclusion, definitely. It may, as Justice Zondo says, be an oversight. But I go further to say it is of the genre that Justice Cameron is
I'm sorry, Mr. Mpofu. Isn't it that after the elections, Parliament sit? In the first sitting of Parliament, the President is elected.
Correct.
And that is why then, in the process of electing the President, the Constitution gives us the details as to how it should happen. But we know from Section 57 of the Constitution that Parliament is the master of its own procedures.
Correct.
So the drafters of the Constitution knew that after the first sitting, Parliament will adopt rules which would regulate its business. And in those rules, Parliament will deal with these issues. So it was left to Parliament to determine whether certain voting should be done by secret ballot or not. Isn't that the position, the structure of the Constitution?
No, it is not, Justice Chapter. Because if that was the case, then the section that deals with actually what's going to happen if the motion of no confidence carries. What will happen is that within the next month or so, the clock will be wound exactly back to June 2014. Even though Parliament has been there, it has done all its rules, but exactly the secret ballot vote that will happen for the replacement president is still going to happen in exactly as if it was day one. So that can never have been the motivation for the chapter 3, rather schedule 3.
Can I draw your attention to section 57?
57.
Let's look at section 57.
Yeah.
It says the National Assembly may determine and control its internal arrangements, proceedings, and procedures, and make rules and orders concerning its business, with due regard to representative and participatory democracy, accountability, transparency, and public involvement. The rules and orders of the National Assembly must provide for, and it lists a number of issues.
Yeah.
What does that tell us? Doesn't that tell us that the Constitution has left it to Parliament to determine these issues? More so, if you go to section 59, you'll see that section 59 does something that is not ordinarily done. Rights may be limited. Rights in the Bill of Rights may be limited by rules of Parliament in section 59, just to show that how important the drafters of the Constitution regarded rules of Parliament to be.
Yes. Maybe before you answer, all the instances, all the countries you referred to, all the countries that Mr. Bartlander referred to, where voting was or is done by secret ballot, or courts spoke in support of voting by secret ballot, the rules of Parliament in all those jurisdictions make that provision. Just to support what, well, to add to what my brother has said. Yes. Parliament has itself, in all those instances, decided that this is how it's going to be done. And courts came in to interpret what Parliament, in the exercise of its constitutional power, had decided to do.
Chief Justice, I would differ slightly with that. In the case, for example, of Ghana, the Constitution prescribes a secret ballot. In the case of Korea,
the rules.
Well, Mr.
Same Botswana, Zimbabwe, Germany, all these other jurisdictions, the rules prescribe secret ballot, not the Constitution as such.
Well, in the case of Korea, not even the rules deal with the question. What happened in South Korea in 2016 is that, in actual fact, in the impeachment of the president there, a secret ballot was used.
But who decided?
Well,
Was it the court or parliament?
no, of course, it was not the court, but the rules, all I'm saying is that it's not as if the rules provided for that situation, which is exactly why it was challenged. That challenge failed.
Please allow me, Mr. Mpofu.
Sorry.
Who decided that it be done by secret ballot? Remember, we are dealing with my brother Jafta's question.
Yes.
It's like I'm a staff writer here.
Yes.
Who decided that it should be by secret ballot?
Well, the answer is it could have been Parliament itself. It could have been the Speaker. We don't know.
No, please. I'm sorry. I'm sorry. The point I want to make is it is not the court that decided so.
No, of course.
It was an internal arrangement within Parliament itself. Is it not so?
Absolutely.
Now deal with my brother's question.
Yes.
With that understanding.
Yes. And by the way, before I deal with that question, that's exactly what the UDM was asking for. That's why we wrote a letter to the Speaker. It was not to say the court must decide. It was to say she must decide.